Hello and welcome to Grace Tutorial. In this video lecture, we will be discussing about one of the most important parts of the Constitution of India and its salient features. In the previous lecture, we had discussed about the fundamental rights and a little more introduction about the fundamental rights. But here, we will discuss about the various things which comes under the article 14 to 18. So if you look at the fundamental rights which is guaranteed by the Constitution of India, we have 6 fundamental rights. And in these 6 fundamental rights, in this video lecture, we will discuss the first fundamental right, that is the right to equality. Basically, the fundamental rights comes in Part 3 of the Indian Constitution under Article 12 to 35. So under Article 12 to 35, it comes in Part 3 of the Indian Constitution. So the first right that we have is the right to equality. The right to equality, it comes under Article 14 to 18. So you may have a doubt that what about this Article 12 and what about this Article 13? We had already discussed about Article 12 and Article 13, and if you are having any doubt regarding to those articles, I request you to go back of the video lectures and watch it so that you can get it very clearly. So let me give you the glance of Article 12 and Article 13 a little. You see, Article 12, it talks about the state, the definition of the state. Similarly, Article 13, it talks about the law. That means the laws which are inconsistent with or in derogation of the fundamental rights will be declared as a null or void or unconstitutional by the Supreme Court. That means Article 13 talks about the law, whether it may be the temporary law or it may be the permanent law. So that's all about, this little bit understanding of Article 12 and Article 13. Now here, this first right that we have, right to equality, and this right comes under Article 14 to 18. We will discuss each and every article of this right very clearly so that you will understand every part of this video lecture. Article 14, the first one, Article 14 talks about equality before the law and equal protection of the laws. That means the state shall deny any person, the state shall not deny any person equality before the law and equal protection of the laws. You need to remember, this right confers on all the persons, including the foreigners. That means this equality before the law and equal protection of the law, this right is available to both the citizens of India as well as the citizens of other countries like the foreigners. But there should be a legal persons. So if you observe it very carefully, here we have 2 terms. One is the equality before the law, another the equal protection of the laws. The equality before the law, this concept has been originated from the British Constitution. Similarly, the equal protection of the laws has been originated from the American Constitution. I repeat it. If you look at equality before the law and equal protection of the laws, which the Article 14 deals about, equality before the law is the concept which is originated from the British Constitution. In the same way, equal protection of the laws is also a concept which is originated from the American Constitution. So what's all about the concept of equality before the law and what is about the concept of the equal protection of the laws? Let me give you a brief understanding on this. If you look at the equality before the law, of course it is originated from the British Constitution, no doubt. But what are the special cannoties on it? Let me tell you some of the cannoties. The first cannotty that we have, according to this concept, the absence of any special privileges in favor of any person. That means the equality before the law says that there shouldn't be any special privileges for any other, any particular person. That means the absence of the special privileges in favor of any particular person. Absence, that means, special privileges for the favor of a particular person should not be there according to the equality before the law. So this is the first cannot. So what's the second one? The equal subjection of all the persons to the ordinary law of the land, which is administered by the ordinary law courts. That means there should be the equal subjection of all the persons to the ordinary law of the land, and that is administered by the ordinary law courts. That means everybody is prosecuted under the ordinary law courts if he or she is is committed any offense. And the next cannot that we have, no person, whether rich or poor, high or low, official or non-official, is above the law. That means everybody is equal before the law. So let me write this cannot for you. No person, whether rich or poor, high or low, official or non-official, is above the law. So this is the third cannot, important cannot, which is given by this concept, that everybody is equal before the law, whether rich or poor, high or low, official or non-official, everybody is equal before the law, nobody is above the law. So my dear students, what are we going to discuss here? What are we discussing here exactly? We are discussing the equality before the law. This equality before the law has been originated from the British Constitution. But what are the special cannoties? What are the points under this concept? I have written the 3 important points under this concept. There should not be a special privileges in favor of any particular person. First point. Second point, the equal subjection of all the persons to the ordinary law of the land, which is administered by the ordinary law courts. Everybody is subjected under the ordinary law of the land. And the third one, no person, whether rich or poor, high or low, whether he is official or non-official, is above the law. Everybody, even you and I am, everybody is equal before the law. So these 3 concepts, these 3 things, it cannot is in the concept of, it comes under the concept of the equality before the law. Let me tell you one more concept in this line. We have equal protection of the laws. Well, initially I have said you, this equal protection of the laws has been originated from the American Constitution. But what are the cannoties according to this, according to this law, equal protection of the laws? According to this concept, I have, that means equal treatment under equal circumstances. Equal treatment under equal circumstances. Yeah. So the first cannot which comes in this concept is that equality, equal protection of the laws, equal treatment under equal circumstances. That means everybody is treated under the equal treatment in the similar situation. Everybody is treated in the similar situation equally. So that is what all about. The first one, equal treatment under equal circumstances. There should be equal treatment under equal circumstances according to the concept of equal protection of the laws. And the next one I have, like should be treated alike. like should be treated alike, but unlike cannot be treated in a similar fashion. Yeah. So this is also one of the most important connotation which comes under this concept. Like should be treated alike, but unlike they cannot be treated in a similar fashion. So these are I have just represented here the two connotations of this concept, and there are many other connotations. Equal protection of the law says that the equal treatment under equal circumstances should be there. Similarly, the like should be treated alike, but unlike they cannot be treated in a similar fashion. That means if you look at equality before the law and equal protection of the laws, the connotations which is the connotations which comes under this this concept, as well as this connotations which comes under this concept, the former one is a negative concept, while the latter is a positive concept. This is also that you need to remember. The former is a negative concept, and while the latter is a positive concept. Well, so what have we discussed here? We are actually discussing Article 14 of the Indian Constitution. That is right to equality. That means equality before the law and equal protection of the laws. Of course, Article 14 to 18 talks about the right to equality. So Article 14 specially talks about the equality before the law and equal protection of the laws. So what are the equality before the laws and equal protection of the laws, and from where this concept has been originated from, and what are the special connotations which comes under this concepts, and what is the former one and what is the later one? Everything we have discussed in a very detailed manner. And now we need to discuss that what are the special immunities, that means what are the exceptions to this equality. Let's have a discuss. So if we look at some of the exceptions to this equality, that means the rule of equality before the law is not absolute. There are some exceptions, the constitutional exceptions and other exceptions to that. Well, according to Article 361, according to Article 361 of the Indian Constitution, what happens basically? The President of India as well as the governor of the different states, they enjoy the power of immunity. That means the first point is that they are not answerable. They are not answerable. Yeah. They are not answerable. That means to whom? They are not answerable to any court, maybe the High Court or the Supreme Court. They are not answerable to any court for the exercise of the performance or for the performance of their duties and the responsibilities. So that is what the first immunity which the president as well as the governor enjoys. Similarly, the another immunity that which is enjoyed by them is that no criminal proceedings shall be instituted against the President of India till he remains in the office of the President. No criminal proceedings. That means no criminal proceedings shall be instituted shall be initiated against the President or the governor of the different states as well as the President of India, in case of any other matter. And the next one we have, there is no process of imprisonment. So no process of imprisonment to the president or the governors of the states in any case. It may be the criminal case or it may be the civil cases. Similarly, we have fourth one, that no civil proceedings can be instituted by, against those against the president as well as the governors. So what are we discussing here? We are discussing about some of the constitutional exceptions, the exceptions or the immunity power which is given to the president of India as well as the governors, that they are not answerable to any court for the exercise of their performance of the powers and duties, for executing their responsibilities. They are not answerable to any other courts. Point number 2, no criminal or no civil proceedings takes place or instituted against the president or the governor. They have been given such immunity power. And then no process of imprisonment also takes place. Well, so what are such other exceptions? You see, there is no process of liability. That means any person may do the publication in a newspaper with respect to a newspaper or by television or radio or any other, that no person shall be liable to any court in respect of anything said or publication of the newspaper. So that is what they have the right. No person shall be liable to any court in respect of anything published in the newspaper or the magazines, etc. Similarly, no member of the parliament shall be liable in any court in respect of anything said or vote given by him. Shall be liable to any court in respect of anything said, in respect of anything said or vote given by him. Similarly, no MLS, member of the legislative assemblies, no MLS shall be liable to any court in respect of anything said or vote given by him, in the state legislatures. That's also one of the immunity which is given to them. Similarly, we have another immunity, that you see, the foreign rulers or the ambassadors, they enjoy the power of the immunity. That means no cases will be instituted against them till they are remained in the office. That means they enjoy the complete power. They enjoy the immunity power which is given to them. The foreign rulers. And ambassadors. The foreign rulers and ambassadors. Similarly, the military, the UNO, the United Nations Organization Agency also enjoy the diplomatic power. So if you look at this, these are all the different immunities which is given to those people, under Article 361 of the Indian Constitution, the immunity power given to the President of India as well as the governors of the states, that these are the following points that we need to remember in, exceptions to equality. Because we need to understand, while we are studying about the equality before the law and equal protection of the laws, that we also need to understand that why this equality before the law, the rule of equality before the law, is not absolute, because there are some exceptions to that. So what are these exceptions? exceptions to the equality. We have understood in a very detailed and systematic manner. I hope you understood that what are the exceptions, constitutional exceptions or other exceptions which is given, which comes under the exceptions to equality. So here one thing that you need to understand, that the rule of equality before the law is not absolute. So the question becomes that, is the rule of equality before the law absolute? No. The rule of equality before the law is not absolute. Why? There are some constitutional exceptions or other exceptions to that. So what are the exceptions that I have written here? And I think it's better that you note down these points, which will be very much helpful for you. And the next we will discuss about another article which comes under this right to equality, that is Article 15. Well, if you look at Article 15, Article 15 talks about the prohibition of discrimination on certain grounds. So the Article 15 says that no person, the state shall not, let me write this for you, the state shall not discriminate against any citizen only on the grounds of religion, race, caste, sex, or place of birth. So Article 15 talks about the prohibition of discrimination. So the state shall not discriminate against any citizen only on the grounds of religion, race, caste, sex, or place of birth. So this is the statement which is given under Article 15. But let us try to understand briefly that what is this Article 15 talks about. If you look at this line, you will find out two most important, two crucial terms. One is the discrimination, another is the only. So what does the first one, that is the discrimination, talks about? The discrimination refers to, to distinguish unfavorably from others. Discrimination means to distinguish unfavorably from others. So what about the term only? Only means, the state shall not discriminate against any citizen only on the grounds of religion, race, caste, sex, or place of birth. But, there is no prohibition for any other grounds except this. So that's why the term only is utilized here. That means for any other ground, only means limited prohibition. There is basically, if you look at this, there is basically a limited prohibition that, for other grounds, the state is not, there is no prohibition for other grounds. So that's why here it is written only on the grounds of religion. That means only on the grounds of the religion, only on the grounds of the race, only on the grounds of the caste, sex, or the place of birth, that if you are not allowed to enter in any of the, the public places like, the restaurants, like hotels or the parks or something like that, then it's like a violation of the fundamental right which you have. So that means no state can, discriminate against any citizen only on the grounds of any other things. That means there is no discrimination. The discrimination is prohibited. So you can go to any other, places. You can reside there. You can visit there, and you are accessible to any shops or the restaurants or something like that. So that is what here it is said about the discrimination. In this line, we need to remember, one is the discrimination, another is only. Discrimination means to distinguish unfavorably from others, and only means, only the discrimination. The discrimination only on the basis of race, caste, sex, or place of birth, on the religion, etc. Similarly, but you need to understand that the Article 15 is also not absolute. Why? Because there are some exceptions to this. But what are the exceptions to this Article 15? That is what the prohibition of discrimination on certain grounds. The exceptions are that, the first exceptions, the state is permitted to make the special provisions the state is permitted to make the special provisions for the women, and children. Yeah. So the state is permitted to make the special provision for the women as well as the children. So this is one of the exceptions to that. That means, you see, how, for example, the women have been given, the special, the reservation. There is a reservation for the women in the local government bodies. In the local bodies, the seats have been reserved for the women. That the women, there are the local government body seats which is reserved for the women. So this is also one of the special provision which is given by the state. That's so the state is permitted to make the special provision for the women. Similarly, for children as well, the free and compulsory education is given to the children aged between 6 to 14 years. This is also one of the exceptions to this, the prohibition of discrimination on certain grounds. Similarly, we have another, the state is also permitted to make the special provisions, for the socially and educationally backward classes. Socially and educationally backward. Classes. So this is what all the exceptions. That means there is a socially and educationally backward classes. The people, those who are there, they also have been given the special provisions under this article. So these are the exceptions of this Article 15. So you need to understand the Article 15 talks about the prohibition of discrimination on certain grounds. That means the state shall not discriminate against any citizen only on the grounds of religion, race, caste, sex, or place of the birth. And here you need to remember the two most important terms. One is the discrimination, which refers to that to distinguish unfavorably from others or to make an adverse distinction. And another, the only. That means there are no other grounds are prohibited according to this article. Only on the grounds of religion, race, caste, sex, or place of birth. There is no discrimination. So this is what the statement given under Article 15, and the exceptions also that I have written for you. And I think if the exceptions that you would remember, it would be helpful for you for the examination point. Similarly, the next one in this article right to equality, which comes under 14 to 18. So 14 we have finished and 15 also we have finished. Now The next one we will discuss briefly, that is Article 16.